Welcome to IP Author, everybody. My name is Manik, and I head the growth for IP Author. And we have with us Lise Shipsides today. She's a patent attorney. Lise, can you introduce yourself to our audience today?
Hi, I'm Elizabeth Shipsides, or you can call me Liz, and I'm a patent attorney. I've worked at law firms, companies, and also been a former examiner with the U.S. Patent and Trademark Office.
So these are like four different test cases that we have taken. So these test cases belong to these companies. So what we've done is like we've taken the first independent claim that was rejected, and we've looked at the applicant submitted arguments. And these are the tool submitted arguments, the tool suggested arguments rather. And we've made a comparison and we've provided a match score. So the similar thing we've done for the applicant submitted amendments and finally the match score also. So I wanted to highlight something here for our audience. So whenever the tool suggested more than what the applicants submitted, we've given the tool higher score, because always the tool is going to be more comprehensive than the applicant. So in such scenarios, like we've given the tool a better score, and we are going to talk more about this with Lise in this podcast. What are some of the key challenges that you face when responding to office actions, and how can AI tools help address these?
Well, not too long ago, I had an office action on an electrical invention with some pretty intimidating circuits. My background is in chemical technology, so getting up to speed on this was a real challenge. The specification was sparse, and the prior art was dead on. I found myself staring at the claims, wondering how on earth to amend them. Sometimes I couldn't think of an amendment or a strong argument because the spec didn't give me much to work with. And then there's the constant question of how is the examiner going to receive my amendment or argument? There's so many different approaches I could take, and but which one will actually advance prosecution? It's a lot of deep, hard thinking. And honestly, there are times when I just feel like I'm spinning my wheels and going down rabbit holes without making any progress. In those moments, I think it would be great to have someone to talk to, someone to bounce ideas off of. And let's face it, partners, your colleagues, they don't always have time to help you figure things out. So I really think that AI could fill that gap. It could be like a companion that I can consult anytime without feeling like I'm bothering them. AI could help me get up to speed on unfamiliar technology, especially for patent applications that I didn't draft, but now I have to respond to their office actions. At the end of the day, there's always that lingering feeling. Did I pursue the best avenue? Did I miss a better amendment? I think an AI could really help me explore different options and boost my confidence in the choices I make.
Wow, Lee, so you kind of like belong to the 1 or 2% of the patent attorneys who have embraced the AI tools of 2024. And it's a privilege to be associated with you, Lise. So moving on to the next question that I had for you, Lise, could you discuss the efficiency gains you've experienced using AI for analyzing and responding to office actions?
Absolutely. Using AI for analyzing and responding office actions has transformed my approach to these tasks. One of the biggest advantages is AI's expansive knowledge of technology. It's not just about analyzing what's explicitly stated in a reference. AI can often understand and infer what's inherent or intrinsic to a particular technology or industry practice. This means that even if a reference doesn't directly address a specific aspect, AI can recognize it based on broader industry trends or common practices. For example, I recently dealt with an office action where the references didn't explicitly cover a crucial feature of our invention. However, AI was able to identify this feature was a common practice in the field, even though it wasn't in the reference. This insight allowed me to craft a more targeted response, focusing on the unique aspects of our invention rather than getting bogged down by less relevant details. Also, not too long ago, I faced an office action where the examiner pieced together 5 different references to reject an independent claim based on obviousness. It was very exhausting for me to try to figure out how each reference was being used and whether they truly supported the examiner's position. This kind of piecing together often suggests that the claim might not be obvious and might be a sign of impermissible hindsight reconstruction. I called the junior examiner to expedite the prosecution, and of course, she requested a detailed written response so she could present it to her primary examiner or supervisory patent examiner or SPE. In this situation, having an AI to help me would have been invaluable. AI could have helped me analyze the references more efficiently, identify potential gaps or inconsistencies, and suggest amendments or arguments to counter the rejection. The AI tools can streamline the process by dismissing weaker avenues or arguments that could be distracting, and they can sift through vast amounts of data and highlight the most relevant prior art and key information within each reference, saving time and reducing my mental load of sorting through the numerous citations and their details. This focused approach allowed me to zero in on the most pertinent issues and address them more effectively. Overall, I think that AI brings significant efficiency gains. It enhances the accuracy of searches, speeds up the review process, and provides targeted insights, making patent prosecution not just faster, but smarter. I think it's an essential tool for modern patent attorneys, helping us navigate complex rejections and find the best strategies for advancing our cases.
Wow. I see a lot of hard work and due diligence that goes behind the scenes. So it's amazing to work with you, Lise, on this. So the next question is based on the recent benchmarking data, of course, audience, I had shared the Excel file that I just showed to you. I had shared it with Lise a few days back, and because I wanted her to prepare and look at the responses and provide her thoughts. So now this question is on the recent benchmarking data. So how do AI generated responses compare with traditional applicant submitted responses in terms of comprehensiveness and accuracy?
Well, based on the recent benchmarking data, AI generated responses perform quite well compared to traditional applicant submitted responses in terms of comprehensiveness and accuracy. The AI responses show a solid match and indicating that technology is making significant strides. We anticipate that the AI will continue to improve, becoming even more comprehensive and accurate over time with advancements in technology, data availability, refinement of algorithms, feedback and learning, integration of new techniques, and collaboration and knowledge sharing. However, achieving the right balance between conciseness and comprehensiveness is crucial. From speaking with examiners and drawing from my experience as a former examiner, it's clear that some examiners prefer shorter, more targeted responses. The goal is to be concise and focused while avoiding the pitfalls of argument by estoppel, which can arise from making too many arguments. As AI technology evolves, we expect it to refine its ability to strike this delicate balance more effectively.
Wow, yeah, the keyword is like the delicate balance, right? So that's a takeaway for our audience today. And the next question is also on the benchmarking results. So what trends have you noticed in the AI responses from the benchmarking results that could indicate areas of improvement or strength?
In analyzing the AI responses from the benchmarking results, one notable trend is that the AI could improve how it handles claim amendments. My initial observation is that the AI often cedes more scope than it might be necessary. To address this, a more effective strategy would be to focus on what a reference does not teach, in addition to what it does teach. By framing arguments and amendments around the gaps in the prior art, what it does not disclose, we can clearly highlight the innovative aspects of the claimed invention. After identifying these gaps, the AI can then address what the reference does teach and how it differs from the claimed invention. This approach allows for a more nuanced analysis, emphasizing the unique contributions of the new claims. Such refinement could lead to more robust and persuasive arguments, ultimately enhancing the quality of the responses and making them more compelling.
Okay. And from the benchmarking analysis, what has been the most surprising finding about AI's performance in office action responses?
Um, from the benchmarking analysis, the most surprising finding about AI's performance in office action responses has been its ability to understand both the claimed invention and the prior art and to eloquently articulate the differences between them. The AI's proficiency in grasping technical detail and clearly distinguishing the innovative aspects of the claims from the prior art is amazing. This capability allows the AI to generate responses that are not only accurate, but also effectively communicate the uniqueness of the invention, demonstrating a level of sophistication that is impressive and promising for future development in patent practice.
Got you. And how does AI aid in the strategy and decision-making process during the office action phase?
AI plays a crucial role in the strategy and decision-making process during the office action phase by offering a range of arguments and amendments for consideration. With AI's assistance, practitioners are presented with various amendment options, which enables them to evaluate all possible strategies more effectively. By analyzing the arguments and amendments generated by the AI, practitioners can target specific weaknesses in the references and refine their responses accordingly. This approach not only streamlines the decision-making process, but also enhances the practitioner's ability to craft targeted, effective responses to office actions.
Okay. And from a limitations perspective, what are the limitations of AI in the context of office actions, and how do you compensate for these in your practice?
Well, AI has some limitations in the context of office actions. A significant challenge is its ability to fully grasp the nuances of prosecution history, which is crucial for crafting effective responses. Currently, AI may not capture the complete context of past interactions and decisions, making it difficult to fully understand the evolution of a patent application. Another limitation is the lack of the human element. AI cannot conduct examiner interviews or build personal rapport with examiners who respond to interpersonal interactions. To bridge this gap, I use icebreakers and strategic communication techniques to foster negotiation and compromise. While AI provides valuable data and generate arguments, the human touch is necessary for navigating the subtleties of examiner relationships and facilitating productive discussions. I also need to engage with inventors, and it requires a personal touch that an AI cannot provide. I ensure direct interactions with inventors so I can understand their perspective, so I can draft the appropriate claims. So the blend of AI generated insights and human interactions creates a well-rounded approach to managing office actions, balancing technical accuracy with effective human communication.
Wow. So that brings us to the end of this podcast episode. Thank you so much, Lise. Thank you for your time today.